Okay, I want to do a review for you for weeks 4 to 8. This is going to mostly focus on where you are as a class, so it's particular to the answers that you all are giving me and how you're interacting in the Blackboard and Google Forms. So we want to start with this kind of, hopefully you see now that rights are not automatic, right? They don't just happen. You don't get them just because they're written down somewhere. We live in an unequal social environment, and so people are going to try to take advantage and benefit from that. So you read some cases here. In Amistad, you'll see that the rights claim was to be free, that they claim they were born free. Many of you believe that. But under whose law? Because they weren't free in Spain. They wouldn't be free in the United States if they were allowed to continue to live there. So the judge in that case basically made the argument that they were free simply because they were at sea. And because there is no slavery law in the ocean at that time, and they were not in Spain, otherwise that judge couldn't hear the case, so he didn't have the power to detain them. So he's not exactly saying that they're free in the sense that he's declaring them free and they get to walk around thinking that. He's saying that he can't arrest them on U.S. soil because he doesn't have the authority, because there's no law at that time establishing that he can do so. Similarly, in Scott, the rights claim was equal citizenship, but many states did not grant citizenship to Africans. And so the court there uses the same principle where they're not declaring anyone free or unfree. They're making the claim that we don't have the ability to give this rights claim any credence because there's no law that says we can. Now, on the other hand, in Plessy, the 14th Amendment had been passed after Scott, and so the claim here in Plessy was, well, we should be given equal treatment to white people because of the 14th Amendment. And it says there's equal protection of the laws. The court in that case, however, said equal protection doesn't mean equal treatment. And it's very similar to the argument that Ronald makes in a different post, that there's an equal opportunity for treatment, but you can't force people to treat people equally. And so if people don't want whites and blacks in the same spaces, then the court can't do anything about that. A different approach in Brown, and at the end we'll talk about what happened, how did the court change so much from Plessy to Brown. And in Brown they say that the 14th Amendment does require equal treatment, not just equal opportunity. However, even though they said that, schools continued to get more segregated, and they are more segregated now than they were in the 1950s. In addition, so you can look up that claim. I think many of you should do it. There's a great map you can look up called the segregation map, and it'll show you exactly what we mean when we say segregation. Many of you think, well, no, Kingsborough and the schools I went to are very diverse. And the issue would be, you need to understand who was separated at the time in Brown, right? It's the rich white kids from everybody else. So if you consider yourself white but not rich, you're with the everybody else. So you're being segregated as well from the rich white kids. That's what was going on in Plessy, that was going on in Brown, and it happens today. So the question becomes, well, how is that possible? If the court said you're not allowed to do this, how come people are still doing it? Well, because the court in Plessy was right. Just because the court says something is right or wrong doesn't mean everybody's going to follow it. The additional issue then is also the cost of education, which wasn't an issue in 1950s, is now so expensive, a high quality education, that most Americans, regardless of race, class, gender, sexuality, or ethnicity, can't afford equal education. This is an issue that has not gone to the Supreme Court yet, right? But you see the big social inequality there. And then finally, in Baker, the rights claim was a basic one person, one vote. But politicians, even since that case, and more even today, have been trying to deny the vote to millions of people in America. And so, once again, you see rights aren't automatic, and there certainly can go either way in the court. Sometimes the court says there's nothing we can do. Other times they say, well, this is what we think, but then nobody really does what they say. So it's very rare that you're going to get everybody on the same page. And that's, I think the only example I can think of off the top of my head is the right for women to vote. I haven't heard many people saying women shouldn't have the right to vote today, but I suppose people might still say that. I wanted to pull some of the discussion board posts because I think they're useful. You see that one student was able to take Plessy and Ferguson to show this idea that they have about cause and effect, that one thing sets out this idea of segregation, or I would probably say it doesn't really start segregation, but it recognizes segregation as okay, and then the court later says, well, now we don't think it's okay. And now you should also see that with the recent Supreme Court case that the court has now said segregation is okay again. And so this is, you can go back and forth, back and forth, back and forth. Again, why, right? Well, because judges are human beings who are part of social groups, and social groups have different ideas about what's fair, what's not, what's justice, what's injustice, and what segregation is, what it isn't. And so there's going to be changes over time. Another student, that was a comparison. Now I want to show a contrast. A student shows that there was some change because of the 14th Amendment, and that whites felt that they could still benefit even with the change in the law, and were able to do that through interpretation, but that's been difficult, right, over time. It's been harder and harder for whites to maintain their domination and their special privileges, and I think this is why you see some white people, actually not even really that many, but some white people getting offended that they could be losing their political influence. And it makes perfect rational sense, right? Because they are losing their political influence. Another student points out from the textbook, which I always love, when you use the examples there, because it shows me that you're engaging with the material, that basically they pull out the language. And then they give you some ideas about what they think about that, right? And so we want to think about not just what the textbook says, not just what the courts say, but also how this applies in your everyday life. But then I want to pull out another view, right, where one person thinks maybe we can move towards equality, another person says no, it's not possible. So then you kind of wonder, what are the courts for, right? If equality is impossible, and the 14th Amendment's promise for equal protection of the laws is not something we can actually do, why bother even having courts? That might be a big question to think about. So how do we get into this mess? Well, part of it is what we call the politics of rights, and we being legal scholars. And this has been at least since the 1960s, where scholars have been trying to figure out what is going on with this contradiction, right? If rights are supposed to be so important, if they're in the Constitution, if they're in the Bill of Rights, if they've been established through legal cases, why is it so hard for society to actually follow those rights? So we've kind of repeat this, right? Rights are not automatic. On the other hand, the basic simple answer, it's not probably your favorite answer, but I'm going to show you what it means here, is that people have different interpretations, and very often they have interpretations that contradict their own position. So for example, Ronald wants to be free from reading Marx. He doesn't want to have to read Marx. Yet on the other hand, he has the right to free speech under the First Amendment. So he has the right to free speech and to talk about what he wants to talk about under the First Amendment. However, he doesn't want other people to talk about what they want to talk about, right? So you see that contradiction there. Jean points to the fact the rights have been mostly used by and for white men. But Jean also has this same right to free speech that Ronald does, and so they're able to talk about that claim, right? And so there's a contradiction there as well. If people don't have rights, then how is it that they do use them? Does it matter that this right is granted by me in the context of this class? In other words, you could be in another class where the professor doesn't let you talk and doesn't let you criticize the materials, or doesn't let you engage in any outside reading. I would say many of you are very lucky to be in a class where I want you to criticize the materials. I want you to engage. There's nothing wrong with disagreement. It allows me to help you think deeper and to correct some of your errors as you're working these ideas out. Many of you have very strong positions. My job is not to change those positions. My job is to help you make those positions make more sense. And so this is a class in which free speech is very, very, very wide. You get a lot of leeway, and I encourage you But I also have the right, with my free speech, to correct mistakes and to correct errors, especially when they're factual errors, and especially when you're contradicting yourself. The problem with this, of course, right, is kind of where you see different people experience the world differently. So some people see the World Trade Center attack and then the Patriot Act as good things. But E-Ray points out here that it wasn't a good thing in his perspective, that many rights were taken away. So this begs the question, right? Like, if I took away your rights, or if the Congress has taken away your rights, really, what can you do, right? If the previous student, Brianna, was correct that the equality is impossible, then that means those in power, those with more political freedom, are going to not listen to what you have to say. And then, so are the courts a useful place for you to use? Is there something else that you should be doing? And so again, Brianna helps us see that, even though we'd like to believe that we don't benefit from previous generations, we'd like to believe that the problems of racism have been solved, or sexism have been solved, or unequal employment have been solved. They haven't. And so they come back up, and they are very much a part of our society. The other issue you should be thinking about is it's not just that they're a part of our society. It's very important, and it's very true, and Brianna makes a good point here. But they're also embedded, they're written in to the Constitution, and they're written into the legal cases. So for example, you're going to think about this case more and more for the final exam, but the Dobbs opinion overrules what was law, right? What was the standard? Now, this really raises Ronald's question of anarchy. Are we living in a state of anarchy because the law has now been muddled? It's not clear what the law on abortion is compared to Roe. And before Roe, there weren't any, each state was able to kind of criminalize abortion, yet most didn't. And so, there's this kind of idea here that law is going to fix everything, but in that case, it didn't fix anything, right? In either case, either by making it legal or making it illegal. And so you have to kind of think about this then. How do these issues that we don't like to talk about, that are written into our history, written into our society, and written into the law, how do we deal with them when they come up again and again? And something to keep thinking about is maybe people in previous generations don't want to talk about it, and so they just kicked it forward to your generation. Now it's your turn to think about it, or are you going to kick it down to the next generation? Something to think about. So I want to give you a perspective of how you'd be moving through this class. A lot of students, you focus on the points thing, and I do that because students ask for it and they think it's useful to help them be motivated to continue to complete their assignments. I hope that eventually you're not going to have that kind of support. You're going to have to just write papers and take exams, and you won't know how you're doing in a course until you get those grades. So I want to give you a perspective of what's good and what's bad, right? So if you're still arguing that interpretation is a matter of individual choice after 8 weeks, if you're still arguing that that law is merely a set of rules that everybody's going to follow, or else there's going to be consequences, or if you're arguing that without your definition of law, there's going to be chaos and there's going to be anarchy, which, by the way, is an authoritarian dictatorship position. You'll hear every dictator say exactly the same thing. Then you haven't learned much, right? And it shows that you haven't really engaged with what the Supreme Court does, or what legal precedent is, or stare decisis, or any of the main concepts that we've been talking about in this class. It seems like you haven't understood them at all. That would be fine at the first week or the second week, right? But as you start going through the examples of the Magna Carta, of the Declaration of Independence, of the Civil War, of the civil rights movements, of the legal cases, right? As you look at the social readings as well, you'd start to understand that politics, by the way, politics is the struggle for power, influence, authority, the right to run your life the way it wants. It's not just two people arguing with each other on social media. And it also has to do with your education, right? Are you educated? Are you not educated? Are you a worker? Are you a middle manager? Are you a CEO, right? Your education, your professional norms are going to affect how you interpret the world. As I think, again, going back and reading Ronald's post on how people get more power by making more money is a useful reading. It's good for you to think about it that way, because this shows you now that you're working out this tension between interpretation being an individual choice and the fact that money has a great influence on how people interpret things. And so now you're moving more complicated and you're making your answers a little bit more accurate, as opposed to just your kind of knee-jerk opinion. You'll also start to see the rules are not applied equally to everybody, right? Most judges are going to try their best to be, we don't say neutral, we say objective. They're going to try to not look at bias, or they're going to try to limit their own bias. But it's impossible to completely get rid of bias. Even computers are biased if you look up algorithms and how they discriminate. And so, we can't eliminate bias. What we can do is try to reduce it, or try to make it so that the rules apply in different settings equally, but they're not going to apply to everybody equally. Not everybody has equal resources. You want to start to move towards then, as you're working it out, you want to start thinking more about then patterns that you see across the cases. So that's why I have you reading cases in bunches, and then you should look at your notes and compare them. What's similar, what's different? You've been starting to learn how to compare and contrast, and so far you're doing a good job of that. So you want to start coming up with hypotheses, theories, suggestions, ideas about what's going on in those patterns. You should start to then understand that worldview, your identity, your standpoint, or what we call exegesis, this worldview that you have as you're starting to read through cases, is the same thing that judges do. And so if you're a neoconservative, a judge is a neoconservative, right? So you'll be similar. I think some of you are still working out what that means. Most of you are still focusing on social issues. You're not really talking about the law or the Constitution at all. But that's okay, right? I'm just trying to get you to think about more law. Not only law, but more law. But you'll start to see a neoconservative judge would do the same thing. If you're a left-wing radical, I'll correct, communism is actually attributable to Lenin, not Marx, but if you're a Leninist and you're trying to overthrow the capitalist regime, I can't even remember all the details, then you're going to interpret the Constitution that way, although I highly doubt you'd be interested in law at all. If you're a moderate or an independent or somebody who's trying to give both extremes time, and space, then you're going to interpret the law. Maybe an example of that would be Justice Sandra Day O'Connor. She tried to do what she called a third way. If you're an originalist, like Justice Scalia, you're going to try to think about what would the original judges do? What would the original drafters of the Constitution, like Madison and Alexander Hamilton, think? What did they say in their papers? What evidence do we have from that time period to give us some ideas about what they intended? Then that's how you'd look at it. But everybody's going to have a different perspective based on their worldview, the way they see life. So you have to start to understand that there's exceptions and that the rules are changeable, what we call malleable. They're moldable. They're going to respond to the groups that are trying to make sense of them. And so it's going to be more than a set of procedural rules. It is procedural rules, right? Law does have procedural rules. They have procedures and they have applications of rules, but it's also more than that. And so you want to think about that. Finally, you're going to have to start thinking about this tension between laws, social control, and rights. I'm not going to talk about a lot of that here because I've got some examples a little bit later in this presentation. But first, we want to make sure you've got the basics down, right? A lot of this is just about reading comprehension. Like, sometimes you read too fast and you don't understand what you read. Sometimes you read something and you get a very interesting, wildly wrong interpretation of what you read. I think, as I'll show a little bit with Ronald. But, I want to make sure you've got these ideas, but I also want to give you the percentages here to see where students struggle, right? So students have a hard time with the concept of originalism. The idea of originalism is, what's the purpose of it? It's to have a fixed meaning, so that from case to case to case to case, judges would be applying the same meaning. And that meaning would be some agreement, even though there's extreme disagreement. But if there was possible to have some agreement about what did the founders mean when they said militia, what did that look like in 1780? What was a militia? How do we think about militias now? Because then they were colonies, they weren't states. How do we think about that? They didn't have advanced capitalism now. How do we think about the fact that a corporation can have a militia? That was not possible in the 1770s. So, how do you think about it? at that time, if you were a sailor, if you were a captain, you wanted the government to come protect you, and you wanted to use their militia. If you were going to try to transport your goods from one place to the other, you didn't have enough money to be able to purchase your own militia, and so, these are things that weren't really addressed by the founders, and so it's hard to have a fixed meaning. But the goal is that it would be consistent and predictable. If you're looking for a really good example of this, contract law is the best place to look. If you look for the law of contracts, you're going to see a lot of situations where there's a fixed meaning, so it's consistent and predictable for business people. You want to look for a really bad example of this, you look at torts law. Like what happens when people get in car crashes. There's no fixed meaning, and the law is not consistent and predictable when it comes to torts. And so you have, within the law itself, you have a huge difference between contracts and torts. The main threshold concept for this class is malleability of law. I'm not displeased that so many students look at sovereignty. I think that's great. I think, sovereignty is a really important concept for your life. It's also really important for government, criminal justice, constitutional law. It's something that you're going to have to keep thinking about, even if they don't call it sovereignty, right? But who gets to make decisions and who gets to control whom? Those are questions of sovereignty. But the main threshold concept in this class is actually malleability of law, that there isn't one law, there isn't one rule that rules them all, right? That laws are open to interpretation because they're written by humans in a political process. It isn't established by one group of people saying now everybody has to follow that. That's a dictatorship. In our country, the political process means there's going to be compromise. You're going to get a little bit of what conservatives like, a little bit of what liberals like, a little bit of what independents like, a little bit of what communists like, a little bit of what socialists like, right? All these different groups are all putting their ideas in. And more, they're not really well thought out, right? They're like, the Patriot Act is not an incredibly well thought out document. It's mostly trying to fix a problem that, led to the World Trade Center attack. And not really thinking about problems of the future. An example of the domination of social control violating constitutional rights was Korematsu versus United States. So here you have a Supreme Court case that violated the constitutional rights of not just Japanese Americans, but lots of Asian Americans who weren't Japanese, but who were stereotyped and discriminated against and assumed to be Japanese. And so, this is an example, again, of the courts aren't the place where they're always going to automatically give you rights. Many times they take away rights. And that's because they're in the social environment, right? The court, I'll give you another example here with Trump versus Hawaii. A lot of people like this answer. I like that a lot of people are pushing this answer of the questions of sovereignty are related to the power reserved to the federal government. That's a conservative interpretation. That's a neo-conservative interpretation. That's definitely not a classical conservative interpretation. George Bush Sr. would never have said that. Edmund Burke would never have said that. Abraham Lincoln would never have said that. But neoconservatives definitely believe this, that any question about sovereignty should be reserved primarily to the President of the United States. And the court didn't want to disagree with that in this case. They believed that the evidence they were given, and which was limited, but that the arguments that were put forward by the Trump lawyers, by the administration lawyers, by the Department of State, the deep state as Trump calls it, but in this case he didn't mind it, that they were shown to be a danger because of their national security, because of their nationality. By being from Yemen, we couldn't determine whether they were in a terrorist group or not because of the lack of paperwork and background checks in Yemen. And so there was a bunch of states that don't share information with us that we couldn't confirm. Like, for example, Canada shares an incredible amount of information with us. So if somebody is coming across the Canadian border, we have a fairly good idea. We don't know for sure, but we have a fairly good idea that they're not involved in funding or participating in terrorist organizations. We don't have that agreement with Yemen. And so the court said we can't play the executive branch here. We have to give the power to the executive branch because they've shown us that there's a danger. Now, if they don't show there's a danger, then the question of sovereignty doesn't get to stay with the executive. And so that's where that orange interpretation is incorrect, right? It might be what you want it to be, but that's not the court's decision. The court has never said that. This case is directly linked to Korematsu. So even though Korematsu was based on a violation of constitutional rights, and many people believe that Trump versus Hawaii was based on a violation of constitutional rights, it's consistent in the language that the court uses because of the allegation of a threat to national security. So how do people start thinking about rights, right, if they're not automatic and if they're not always involved? Well, usually it's about experiencing injustice. Most students that you see on the discussion board who are clearly able to identify injustices and rights violations have had their rights taken away from them. Students who tend to see the world as abstract and law being a set of rules or else there be chaos usually haven't had any injustices. They haven't had an example of learning or of experiencing injustice. So the theory is that maybe learning about injustice is one possibility, and I think Brianna seems to be evidence of that you don't necessarily have to experience racial injustice to understand what it would be like to experience racial injustice. There's other examples that I think you could pull from where you've had an experience of injustice, maybe based on your religion or based on your nationality, that you could then have empathy with other people who are having injustice in a different area. It doesn't mean you have to agree with them. It doesn't mean you have to be on their political spectrum. It just means that you understand this is what the court has to wrestle with. Injustice isn't as specific in the courts as it is in social life. Now, how do people start mobilizing and using the law to try to pursue their own agendas? Well, this is a strategy for a more equitable social order, right? I can't see how it could be equitable for a less social order, right? Less equitable social order. People are usually trying to become a system where it's fair and equally applied. So what does this mean? Well, it means for you to be able to do this well, you have to, first of all, accept the reality that you're in a social construction of unequal social relations. We create an unequal reality. It's not there by chance. It's not natural. It wasn't given to us, from aliens. We participate in this. We are either working to make society more equal and live up to the promises of the Constitution and the 14th Amendment, or we're working to exclude people and make things less equal. And again, I encourage you to go back and read Ronald's post about how capitalism and money works to create a less equal social order. So why does this lead to ambiguity, right, in the cases? Well, there's some good answers here from you all, so I'll let you read these. But basically, one student highlights the politics of rights, the idea that rights are automatic, that once you just have a right, then it's going to be granted, is not true. So that already creates ambiguity because people expect things to be one way and then they go to court and find it to be another way. And so now they're not quite sure how to act. The other thing, though, is that we all come from different cultural backgrounds, socioeconomic backgrounds. We have different ways of seeing the world. And so what you call right or what you call wrong doesn't mean the same thing to everybody. So that's also been found in neuroscience, that our brains are wired that way. It isn't just a choice that we make. It's something that our brains do to keep us safe. So why does this matter? Well, if you're focusing on formalism or just what you think the words of the Constitution say, then you're ignoring everyday experience and you're not really going to be able to solve this problem. And so you're going to constantly be disappointed that real humans don't operate the same way as ideal humans, or as James Madison called, our better angels. And by the way, that quote is, if all men were angels, no government, no law would be needed, right? And so we create a social construction of law in order to try to make unequal social relations a little bit more equal. And you can judge how well we're doing. Is it better than 100 years ago? In some ways, yes. In some ways, no, right? And so there's always this complicated mixture. I think you should also go to this extra credit discussion board that I think is really spicing up. It's getting better, so everybody should participate. Get some extra credit here. This kind of argument has been developed in this class by a couple people about a political interpretation of the Constitution. It's an intriguing idea to me because many of you said that there was no such thing when you started this class. that there's only one correct interpretation. Usually it's yours, right? Anybody else's is wrong. So the issue then has become, well, is that political? So some of you seem like, from my point of view, you're extremely political, more political than the average student. But you might be thinking, well, I'm not very political. I'm wondering if you think this is because you have to, join or run for office in order to be political. Again, political means the struggle for power and influence and authority over your own life. Everybody is engaged in this. Nobody's not political. But you might be thinking about politics differently. So I'd like to hear your thoughts. And then how does that apply to an interpretation of the Constitution? Unfortunately, I haven't really seen an interpretation of the Constitution yet. What I've seen are interpretations of social relations. And I don't know that that's necessary because you've already read about that in the book. We already understand how that works. So now we want to see, well, how does that apply to your interpretation? So a lot of you are avoiding this. Not a lot, a few of you. Most students don't avoid this. But a lot of you are having a hard time coming up with your own identity. You seem to not know who you are, what your politics are, and that's making it harder for you to interpret the Constitution and understand legal cases. So you might want to start with that. And I also just want to point out, again, sometimes you want to argue with people, and that might be what you mean by politics, people arguing with people. But despite what you think, in law school we actually learn how to get along with one another and avoid argument, because arguments are expensive. You sometimes contradict yourself. So I think, even though Ronald was trying to make a different point, he made a great point. If you don't have any influence, you really don't have any rights. And how you get influence, according to Ronald, is you make more money. And I don't think I challenge anyone to disagree with that, right? I mean, I don't think that just having $1 billion makes you get to do whatever you want, but it's pretty close. I mean, there's not so many things you can't do. Versus if, I remember when I was just first in college and starting out and working full time, I felt like I didn't have much say over anything. And so I think, as you kind of get more money in life, you do seem to have more influence and more rights. Just starting a case, I feel much more comfortable starting a legal case after going to law school than I did before law school, right? So knowledge is also important, but I needed money to be able to go to law school, right? So I think thinking more about the influence of politics and money as it relates to who gets rights, I think is a very useful thing. By the way, it is a Marxist position that Ronald is giving us, even though he doesn't want to think about Marx or read about him. It's usually the case, though, is that people have misunderstandings based on what they see in popular culture and forget that, what people say about you probably isn't accurate, right? And so that's also true of people who wrote books. It's much better to read their books and see what they say. And I think Marx, for example, I'm not a Marxist, but I think Marx's book on Capital is well accepted by right-wingers, left-wingers, people in the middle, so-called independents, everywhere. The Communist Manifesto, I think, is, in my opinion, not a very clear or well-written document. But you can all have different opinions on whether you think it's a good document, a bad document, etc. But you do want to try to make sure you're keeping politics and constitutional law in the same system, right? They're not separate systems. They are in dictatorships, but in a constitutional republic, they're supposed to be in the same system. This is the whole concept of having a system of laws, not men, as the original founders said. So this leads to this strange contradiction then between social control and rights or resistance, right? People, when they resist social control, they're doing it for one of two reasons. They're either doing it because they say, I have a right and you're not recognizing my right, or they're saying you don't have the right to do this to me. Or the second reason is, they don't care. They're not trying to be a part of society, or they're not trying to they don't agree with the social control, and they're not interested in rights, they're not interested in law, they just want to do what they want. I think that's a relatively small number of people, although it does seem to be increasing. most people are usually basing their resistance on this idea they have of either I have a right or you don't have the right. And what have people been able to see in this class? Well, yes, right, the rights were written by and for one group of men coming from England, largely protecting them against everybody else. And slowly, through the political process, other groups have argued they should also have access to those rights. And sometimes it works, and sometimes it doesn't. Meanwhile, those of us from Anglo-Saxon backgrounds, are wondering what's our role in this. What are we to do? And I think a couple of you are working that out on your own, even though I don't think you're Anglo-Saxons. Thinking about social groups, culture, background, right? These are ways of just analyzing how change happens over time, but how historical injustices can creep back up. They can come back, right? Because a group doesn't live forever. They die and have children, and children can do what they want. So on the other hand, right, social control and rights or resistance are opposites. And so this is important to think about, right? Pure social control, that's a dictatorship. Pure rights would be no government. It's not that hasn't ever been done. That has been done actually many times, but it's only been done in small groups. Your best example, if you're so inclined, is to go back and read the Bible and the New Testament and see what Jesus said about no government. That is one possibility. But more often, where you see this happen is if you go watch pickup basketball. I think is a much easier example than the Jesus example. There isn't a referee, right? But people still use rights claims, right? You fouled me. That isn't right. That's a travel. You're not allowed to do that, right? So they make up rules with each other over time, and that's what they mean by no government. There's no group of people standing over in the corner telling everybody how to play basketball, which is what we have in our political society, is a group of people telling us how to live our lives. That's what we mean by social control. So it's not usually very extreme, but the larger a group gets, the less likely they're going to be free from social control. The bigger they get, the more likely you're going to see social control. So you think like a place like New York City, there's a lot of social control, way more than if you were to go to a small town in Kansas, right? In small town in Kansas, there's going to be almost no social control because there are very few people. And so they're going to be much more, quote unquote, anarchic. They're not going to have a visible set of government officials telling everybody what to do. The other issue I think a student is really right to point out is that there's a lot of people claiming rights, and oftentimes they're like what we saw in an earlier slide. People are contradicting themselves, they're contradicting each other, and judges have to try to sort through this by looking at previous cases and applying those rules, and they almost never apply cleanly. It's always going to be complicated. The other idea is that people want to be free and equal. They want entitlements. A lot of people forget that the Constitution isn't just about rights, it's all about responsibilities as well. And a lot of people I'm seeing in today's society don't want to be responsible to anyone for anything. And so it's interesting, right? It's an interesting time we're living in where people are very difficult with one another. They're not really being very cooperative. And this is what happens in a system like this. Finally, as Ronald points out, a lot of people believe, and I think rightly, there's a great article by a scholar with the last name Cover, C-O-V-E-R, that talks about violence in the word, that for the people who believe in this particular form of social control, meaning a group of people who tell other people what to do, but they provide trials, they provide rights, they provide a process, they believe that form of violence is necessary to control society. Other people, usually called abolitionists, believe the exact opposite. And probably, bringing up Brianna's point, probably most people are somewhere in between. They're not either or, right? I think that's maybe what you mean, Brianna, by independent, that there's people in between the two extremes. I sure like to agree with you. It'd be lovely if it wasn't just two really angry people screaming at each other all the time. And so, obviously then in between is What financial penalties are appropriate? Who should get them? Should they apply to CEOs, or should limited liability apply? Should they apply to police officers, or should qualified immunity apply? How long should people be incarcerated? Should there be probation? Right. So once you have things in the middle of the two extremes, in comes the political process, and people are going to have a lot of different opinions about this. So you should be able to describe this tension and what all those options are in between, using the readings and using the cases. So how do we see this all work itself out? Well, look, here's some examples in the last set of readings on criminal justice problems of trying to balance these different interests. In Gitlow, his speech is limited, so he can't talk critically about governmental change through violence. A lot of students, when they read that, it was, of course, that makes perfect sense. Okay, would you apply that to the far right and the far left today? What about independents who are pushing conspiracy theories about the government in order to overthrow it or change it or question the election results or question the use of democracy? Again, you already know my position. I say, hey, let's hear everybody's opinion. Everybody should have the right to talk, because that's how I interpret the First Amendment. But lots of people say, oh, no, you shouldn't let people on the far right talk about that the election is stolen. You shouldn't let people on the far left talk about the history of slavery in the United States and Virginia. You shouldn't let independents talk about how both political parties are corrupt and take money from corporate elites, right? So how do you manage this, right? If the court said we can restrict Gitlow's speech, then guess what? They can restrict your speech too. In Garrity, a very unusual case, police officers were forced to make a choice between social control. They had to confess that they were accepting bribes, or they could resist. They could use their freedom through due process. So did anarchy reign? Did everybody turn into violent criminals because the court weighed in favor of resistance, of saying police officers don't have to confess that they're accepting bribes? No, of course not, right? So, it's always much more in the middle, black. It's not black and white, it's always gray. But what did happen, right? Now, are police officers more likely to accept bribes because they're not going to be forced to confess them? Should police officers have the same rights as you and I? I think most of us would say yes, right? But some people say no, they should be held to a higher standard, right? So there's different opinions. In Powell, African American defendants were not given any due process. So they resisted. They said, we have rights. But remember, at this time, they weren't seen as equal citizens. So did they have rights? And then how does this affect the 14th Amendment, which said that they do have rights, right? So how is it they don't have rights, even though there's a document saying they do have rights? And are those rights opportunities, or do they have to be treated equally? In Furman, the judges argued that no one can really know what the Constitution means. And specifically, they're looking at cruel and unusual punishment. Nobody really knows what that means. But then they decided that the death penalty was cruel and unusual. But here we are, today, people still put people to death in states, and now police have killed more people than people killed on death row, and they have qualified immunity. So does it matter that the Supreme Court in Furman tried to define what cruel and unusual punishment is? Or were they right when they said no one really knows what this means? In Gates, the Fourth Amendment was deleted, and so a totally new standard. It was no longer that you had to have a warrant with probable cause. Now you could just have reasonable suspicion, and it could be built on the totality of circumstances. So there is no Fourth Amendment anymore in those situations. So does that mean that we need to rewrite the Bill of Rights because it doesn't apply like it used to in the 1790s? Or is that not true? Are the same concerns that the founders had about police doing whatever they wanted true of today as well? So I just provided two examples here, a letter from Birmingham Jail and a power of self-definition, just to give you, well, what is the black perspective according to these two people, right? So for King, the point was that black people haven't had much opportunity to actually put their 2 cents in as to what they think, and so he was kind of pointing out this idea that if you keep saying things are going to get better, or look, things are better than they were 100 years ago, often things that white folks say, but it's not equal. If we're not actually getting justice, then what's the point, right? Just giving me a little bit more isn't the same thing as me being equal to you, and how come you can't recognize my equality? So what Patricia Hill Collins argues, later, 30 years later, is that, well, look at black women. Because they've undergone a similar form of discrimination, they've been able to craft their own identities and tell stories and create little spaces. And those then have competing ideas, new ideas of what justice means, what it would look like, what integration would look like, whether integration is a good thing. A lot of people don't realize that there's still a lot of disagreement about whether integration is even a good idea. Many people would prefer just to have equal separate spaces. So that goes all the way back to Plessy versus Ferguson, right? We're still having conversations about these principles and these ideas. But then I want you also to see how confused students are when they try to think about whether a case has an effect on social relations, right? And it's interesting, right? There's disagreement as to whether they think that the case is useful or not, or having conversations about rights is useful. So you'll see people giving different justifications for that. So why the contradiction? Well, again, Ronald wants to have the freedom not to have to think about Karl Marx. The problem with that is we all have to think about Karl Marx because the Supreme Court did. During the Great Depression and the collapse of capitalism and how it just ruined the lives of so many workers, guess what? People were very interested in Karl Marx and very interested in Lenin and Trotsky and what was going on in Russia at the end of the 1920s in particular. And so they started changing the way the court looks at economic cases and started intervening all over the place for the first time in their history. And so we have to think about this whole class struggle concept and what does capitalism do? What doesn't it do? And if you look carefully at Ronald's articulation here, again, it's very Marxist. He points out that more money buys you freedom. And that is exactly, how we tell people to pursue their careers in America, right? And so it's very ironic that capitalism uses the same language as Karl Marx from 100 years ago, and that Ronald is using it here without knowing he's a Marxist. But we shouldn't be surprised by that, again, especially when we're thinking about constitutional law, because the court has done this as well. They've taken a huge role in interfering or intervening, depending on your politics, with the market economy. And so you got to think about these things. This is very difficult. So why would this happen, right? Well, look, nobody disagrees that capitalism puts an emphasis on profit through private property. No one. That is the basic definition. So why did the English, as they came to the United States, or when they came to North America and established the United States, why did they care about this? Well, they had a really bad history of losing their property. They'd lose their property to invaders, then they'd lost it to the church, and then by other Englishmen coming in with the Orange Revolution. So by the time that they're in the North America and they're negotiating with American Indian tribes, they're negotiating with French, they're negotiating with Spanish, right? There's lots of controversy over private property. And whose property is it? Is it the states? Is it the churches? Is it the countries? Is it the groups? Is it the individuals? And so they looked for examples, largely, almost exclusively from John Locke, on why private property was good and how it might be useful as a way of doing all the things that Ronald is pointing out. Now, other people disagreed, right? Madison disagreed, Jefferson disagreed, Hamilton disagreed, right? Everybody had a different idea, very similar to the disagreements about sovereignty. But this is the American experiment. They agreed to, let's try it out. Let's establish a legal system that protects private property and acknowledge that some people will do better in that system than others. And Congress, it's the job of Congress under the welfare provision in Article 1, Section 8 of the United States Constitution to help the people who don't do as well. And this is largely what the court tries to do during the Great Depression. They also did it in 2008, for those of you old enough to remember what that was like. They also just did it recently during the pandemic, as the government gave all sorts of money to all sorts of people, from corporations to people who just got out of prison. Um, and so, Marxist critique has been firmly implanted into everything that we think about when it comes to the division between those who have power, which some of you, E-Ray, is calling the elites, and those who don't, those who are marginalized or are workers or are in school at a community college. There's not equality there, right? And so these issues have been trying to be debated and thought out for 100 years. It's also important to remember that communism is a political system, whereas capitalism is an economic system. The constitutional republic is the political system. So if you want to critique something, you got to try to figure out the relationship between the constitutional republic and capitalism. They're separate spheres, but they influence each other. And so you should start to understand why private property is more important than human rights, at least in the constitutional law narrative, right? That's not obviously the case if you go look at the debates that people have in other places. So, you also have to start thinking about, is this even right? I mean, is it true? Is the rhetoric of capitalism correct that Kingsborough students would have the same opportunities as Harvard graduates or MIT or Stanford? Of course not, right? Or what about those born into $1 million homes, right, where they don't have to work, they don't have to work, think about having to work? Are those people equal? Of course not. What about other privileges, right? There's not just white privilege, there's not just economic privilege, it's not just educational privilege. We all have different privileges and burdens. And so how do we even start to think about equal opportunity given all of those differences? And then finally, just to think about something, right? This textbook, which some people love and some people hate, is being used in law schools in Texas, Florida, Montana, New Mexico, North Dakota, all Republican states, California, Wisconsin, and other Democratic states. So what is it that these law professors, judges, and lawyers like about it? Well, they like that it gives a social perspective and that it's not just reading the Constitution, which any 8-year-old could do in their house. Would you understand any of it, what it says? No. And I think, again, go back to the constitutional interpretation discussion board and look how Brianna is really trying hard. I really admire and commend her for that, to really apply an interpretation to text of the Constitution. And look how difficult it is. Get in there, right? Put your own interpretation of what she's put on there. The balanced budget is such an interesting concept, right? We wouldn't be in a lot of trouble that we're in financially as a country if they did pass the balanced budget. New York has a balanced budget requirement, and look at the forced negotiations they have. Right now, the community colleges had a lot of money taken away, so you've had a lot of money taken away from your education in order to pay for police, prisons, hospitals, right? These are conversations that in political society people have to argue about what they think is important and what they think is less important. And right now, you're less important. Is that fair or not? That's up to you to decide, right? And then always, I encourage you strongly to read more cases, right? I've excerpted, meaning I cut them so that they're shorter for you to read, because in my experience of 13 years, most students at Kingsborough complain about having to read too much. Generational thing, I think. So there are YouTube videos you can watch that talk about cases. Be careful. It's better to do your own analysis, but don't just believe everything you see. But there's plenty of good videos out there. I've got several videos that go through cases in more depth. You can go to LIII if you just Google that and read full cases. You can also read the arguments in the cases. You can also read the footnotes in the cases that send you to other readings. There's a pretty popular blog that is called SCOTUS blog that talks about what's going on in the Supreme Court right now. You can use Google Scholar case search to look for all sorts of different cases. If you want to get a better idea of what constitutional law looks like at the law school, beware, those textbooks usually are about $500, $600, but sometimes you can find used ones that are for, earlier editions, older books. They're still going to be pretty expensive, but it might be worth going to the library and looking at them just so you get a sense of how this book is different. In many ways, it's very similar. But in some ways, it's a bit different. It provides more of a social context because, in my experience, that's what, and you've shown me, that you lack, that you're not learning quite how to apply what you learned in your sociology, in your political science class, in your philosophy classes. You haven't quite learned those things well enough to be able to analyze legal cases. And so this is helping you by giving you perspectives that aren't always first and foremost in people's minds. And you're bringing your perspective. And so there's a mixture of perspectives and speech. So finally, something to think about as you're preparing for the final third of this class is that different judges take different approaches at different historical moments. Different judges, different approaches, different historical moments, different law, right? So law is different. It's not one thing. They're going to be constrained by cases, which we call stare decisis. Look it up in the vocab section of the book. And precedents. Also look that up in the vocab section of the book. And so you want to start looking at these cases, looking at these precedents, looking for patterns, looking for differences, applying that to your own interpretation. And again, my job is not to change the way that you think or the things that are important to you. It's to help you make more sense. A lot of times you say things that make sense to you, but don't logically make sense. And they're not consistent with legal reasoning, which is what you have to learn in this class. And so this is just practicing. So hopefully some of you will get a little bit better about taking critical feedback, especially if you want to get a good job, a career later in life. And especially for those of you transferring to John Jay, this will get harder, not easier. You will be exposed to deeper sets of analysis, much more Marx, and other theories like Durkheim, and many others, Rousseau, hopefully Bentham. I think that would be a good one for many of you to read, would be Jeremy Bentham. But a lot of different perspectives, so you can think about this from a lot of different points of view. So this has been a pretty comprehensive review because I wanted to make sure for those of you who are still listening that you're getting what you need. So please again, continue to interact with one another in the discussion boards, continue to try to think from your own perspective and develop it a little bit deeper. And please do look at the rubrics and try to improve your learning using that.